For those of you who were here yesterday, we had an opportunity to hear Mark Holden, and I think he did a nice job of framing the growing consensus that we're seeing both on the right and the left in terms of the need to reduce the imprint of the criminal justice system and deal with mass incarceration. And as communities have become more focused on the problem of mass incarceration, of course, one area which has become more ripe for reform is that of the pretrial process. As we look at data on who's in custody, what we learn is that in many communities, particularly in our local jails, there's a high fraction of folks who are being held not because they've been adjudicated guilty of any crime, but they're being detained pre-trial, in some cases, in many cases, because they can't afford cash bail, in other situations, because the court has decided for whatever reason they need to be preventatively detained. Over the past few years, we've seen a growing movement to try and make changes to those systems. As you can see from the headline from just a few days ago here in Philadelphia, it's certainly a topic of active conversation, but one that is being repeated in many communities, right? So across the river in New Jersey, passage of kind of constitutional changes and major reform to their pretrial system that began in 2017. In some cases, we see change being generated through litigation, as we've seen in Harris County, and which is an issue here in Philadelphia right now. Other situations, there's legislative change. Californians are going to go to the ballot shortly and have to vote on a major adjustment to how they think about pretrial. And so there's a lot of interest and discussion about reform. What we're going to focus on today is a set of issues that I think is on the vanguard of the pretrial reform movement, and that's how do we think about and orient ourselves towards approaches in the pretrial space that are supportive of criminal defendants, that allow them to be able to resolve the legal issues that they have in the criminal justice system and be able to move forward and continue on productively and in a flourishing way. And I couldn't be more pleased to have, from my perspective, an ideal set of panelists to talk about this issue. So to my immediate right, we have Keir Bradford-Grey. She's the chief defender of the Defender Association here in Philadelphia, has led a number of innovations in the Defender Associations over the past few years. And one particularly innovative thing that I can't help but mention, in addition to having Keir as a panelist, I can also count her as a colleague. She, working together with our DA, Larry Krasner, launched a very innovative course that brought together students from Penn Law, Drexel, and Temple, all to take a class with Keir and Larry focused on criminal justice reform. So in addition to a panelist, I'm pleased to call you a colleague working to educate the next generation of criminal justice practitioners. To Keir's right, we have James Cadogan. James is a vice president of criminal justice at Arnold Ventures. He has charge over the pretrial portfolio at Arnold Ventures, and we all know, of course, that Arnold Ventures has really been in the vanguard and a leader in developing new data and empirical evidence on the pretrial process, and we'll have an opportunity to hear more from James about some of the innovative work that they're doing in that area. And finally, last but certainly not least, to James's right, we have Hannah Sassaman. Hannah is from the Media Mobilizing Project, and she has worked with affected communities and grassroots activists on a range of criminal justice reform issues, but has really become a thought leader both here locally in Philadelphia, but also now nationally on topics related to pretrial reform. So it's great to have you here, and let me just kind of start the conversation, and maybe I'll direct the first question to you, Hannah. As we think about kind of pretrial reform, you of course work a lot with grassroots folks thinking about where we need to go, and so from your perspective, as we, kind of think about here in Philadelphia and other places, the sort of system we want to have and what reforms we want, what are we looking for? What's the end goal of these reform efforts?
Sure. Well, thank you so much, Paul, for inviting me, and I'm really honored to be on a panel with Keir and with James, both of whose work I respect very much, and to be speaking with all of you today. So as Paul said, I'm a community organizer. I've spent my entire career working at the intersection of technology and racial and economic justice. And so Philly is a really important place to be having a conversation at that intersection. As you know, we're the poorest big city in the United States with the highest level of deep poverty. Until very recently, we had the highest per capita level of incarceration in the United States. So for every person who is up in jail on State Road, in the prisons up there, there's a powerful individual story of the circumstances that brought them there and some of the worst days of their lives. And so one of the things my organization does is we're the fiscal sponsor for one of the 2 bail funds here in the city of Philadelphia, for the Philadelphia Community Bail Fund. And as someone who's Jewish, I usually take Christmas Day as a day when I'm going to go bail somebody out of jail, right? So this past Christmas, I went to bail a young man out of jail. He was a musician. He was a new father. So I sat down there in the basement of the court with some many thousands of dollars, waiting to bring him home. And the circumstances of what brought him there, I'm not going to go into in particular, but the only reason that he was being held on State Road for, I think, something like 10 months was because he couldn't afford to pay his bail. And so I think that a lot of the conversations that we have about how we end the incredible horror of pretrial incarceration really have to do with those individual stories. And if you fast forward a few months after that, that young man was sitting next to Mayor Kenny and a bunch of other formerly incarcerated folks arguing for why we should close the House of Correction, telling the story about the black mold that painted the walls of his cell, about the showers that were either burning hot, scalding the skin, or so cold that you couldn't stand under them for more than a few seconds, like using his own experience to bring the mayor closer to being able to make that commitment to fully close that jail by 2020, and it's currently empty of human beings in cages. And so I think that one of the things that we want, just to get back to your question, Paul, is to center that human storytelling, to center the fact that a person who might be accused of harm, even grievous harm, shouldn't be shunted into a cell based on a 2-minute conversation, or really just looking up and down by a bail magistrate over a closed circuit TV in the middle of the night. Shouldn't be judged in part by a risk assessment algorithm that might be trained, that is trained on a practice of criminal justice that's racist at its root, and it's extraordinarily hard to create a fair analysis of a human being and prediction about them based on such data, and certainly to communicate that bias or unfairness to a judge. And so one of the things that I think we want is to take that moment of decision from a bail magistrate or a judge in a more rural jurisdiction, and instead of looking at that person as a potential risk, as someone who might not come back to court if released, or who might be at risk of harm to another person if released, if you're allowed to test for that, which you aren't allowed in a couple of states in this country. Instead of looking at that person as a risk, how do we completely restructure our pretrial system to evaluate that person's needs, to have a conversation about them, and in fact, an adversarial argument in front of a judge, if need be, about why that person has needs that we can meet for far less money and with far more holistic, truly healing purpose in the community than spending between $50,000 and $100,000 to keep them incarcerated for a year before the resolution of their trial. So just to close, we have very strong arguments, I think, for that in Philadelphia, a lot of which have been pioneered by Chief Bradford-Grey and by her partners, and a lot of which have been pioneered by formerly incarcerated groups like Close the Creek, like the two bail funds, like the 3 participatory defense hubs. I think we have a real chance here in Philadelphia to make an argument for holding people in their needs, many of which, by the way, are very small, holding people in their needs rather than in their risks, and really transforming, based on what we do here, the entire practice of pretrial adjudication nationwide.
Thanks, Hannah. I mean, I think you really raise, a compelling vision of, moving from a system which focuses a lot on risk to one that thinks about needs. But then, of course, we face the practicalities, right? You described, the current scheme we have the 2-minute video hearings, we have little information. And so the question becomes, how do we get from where we are today to something more closely approaching what you describe? And Keir, I mean, you've been really a community leader in thinking through the practicalities of, if we're going to change, what are the directions, and, how is that going to work? And so I'm wondering if you can talk more about some of the ideas that you and other folks at the Defender Association have been developing in terms of reforming the system.
Sure. One, I want to say Hannah, great job at really discussing the issues at hand. And I do agree that I believe that the reason why we are where we are with mass incarceration and with incarceration being overly, I guess I would say biased towards certain groups of people is because we've taken the humanity out of the system. It's been very process oriented instead of humanized. And once you do that, you don't look at people as people, you look at people as liability. And so our system currently is designed to just look at a liability. What if this hits the paper? And it's really, really designed to kind of look at people in the worst light. Because right now, like Hannah says, our pretrial decision making, we're able to have stories of people, and public defenders get those stories all the time, just not at the time where it matters most, when the decision is being made whether to detain someone or release them so that they can participate in their own defense or have access to resources that could help them really tell their story. So our office, because we are at every arraignment that happens in the city, we have a contract with the city to arraign 100% of the people. Very rarely will someone have their own attorney at that time of arrest, but if they do, their attorney may show up. In any event, we understand the flaws of that front end, and so we sought to find a way to force the humanity back into this system. We had a number of different initiatives that we tried. First was our bail advocates that we were funded through MacArthur to have, and they were people that were stationed at the police district to gather information that could be helpful to bringing about a determination that's more holistic. And it sounds very common sense, right? I mean, if you want to make an important decision, you should have more factors and information. The unfortunate part is we were only able to get 2 bail advocates, so we weren't able to do this widespread. But the little bit that we did do, we saw a dramatic improvement in some decision making that was going on because of the information. So we said, what if we had this opportunity to really explore people and who they are and their opportunities to be released and their structures and supports, but also what would be the impact on incarceration to this person and their family, because we leave that out of the equation as if it doesn't matter. And then we wonder why kids are really kind of disheveled and stressed out at school because their parents may be unnecessarily incarcerated, who are the ones that are really active in their lives. So I'm gonna get ready to take that. So what we wanted to do, moving towards this no cash bail reliance, we wanted to find a way to look at our current system and say, hey, are there ways that we can make better decisions for people? And are there ways that we can keep people out of the purview of even getting that opportunity to have bail placed on them? And so I'm going to take you through just briefly this new vision that we created. And I should say this, I am very fortunate to work with some very brilliant people. So some of the people that helped on this was Mr. Aaron Marcus, who's our appellate, one of our appellate attorneys who's on the Supreme Court Rules Committee. So he helped me with looking at the rules that need to be changed to get to this system. And then we have Erin Siegel. I wouldn't tell my children to name their child Erin. Erin's really smart. Erin Siegel, who is our data analyst, who looked at what we're currently doing now and why it would really practically fit. So I'll go through it. Our goals, obviously, is to end wealth-based detention. We've relied way too much on money, and that has been, and thank you to the ACLU for really, really shedding light on this, because that has been the go-to decision. Let's just, cash, let's put cash on it, and whatever happens, happens. But we wanted to provide individuals with an opportunity for individualized hearing, meaning explore who they are, let's get some information, let them actually talk to their lawyers beforehand. I think it would help them. Also, one of the main things that were really, really critical is using community supports. There are so many things that are going on in the community that don't come into the purview of the criminal justice system. And if we tap into those, that can make such a difference in terms of whether or not people are not only supported, but are they accountable with them, to themselves and others who are working to help them deal with their challenges and meet their goals. We think, of course, it'll improve public safety and then save taxpayer dollars that can be used in places that really are necessary for quality of life. We created a system, and right now it looks like kind of an operative of something, but what we wanted to do was look at our current decision-making points and say, hey, where can we create a system that doesn't overcrowd this initial detention hearing? And so we said, the low-level offenses that are currently getting ROR, why are they coming through this system anyway? Why don't we look at ways to take those out of this structure and do what every other county in Pennsylvania does, use a summons process. Philadelphia is the only county that doesn't use a summons process for low-level misdemeanors. And we looked at why that is. We really can't understand why that happened, but we do know Philadelphia has a municipal court and a court of common pleas. That seems to be the difference as to why we send everybody through an arraignment court process. But really, the police can make decisions to give people summons to come to court. Now, there's a lot of different ranges of that decision process. If the DA disagrees because something else that's in the person's history, then the person is sent to another hearing where we determine whether or not this person can be released with conditions or not. So there's mechanisms that are built in there to provide for some individual judgment, even when the charges would mandate a summons process. And that's one of those things that that I just talked about, issuing summons for low-level offenses, and we wrote out all of the ways or things that can do. And so what we figured out is that if we started using this for some of the low-level offenses and the charges that we're looking at, we can weed out about 40% of the people that come into this system. And that would save us time and to have, instead of a 2-minute hearing, maybe a 10-minute hearing that could really flush these issues out. Like I said, we started looking at what we're doing currently. And right now, in the red, these are all the misdemeanors where they get released on own recognizance. So it wouldn't be a deviation from the practice, it'd just be a process issue. And so we had to show our judges, hey, we're not trying to act reckless here, we're actually following what we're doing right now. And so this is our data analyst who got all that stuff together, and this was really great that he was able to do that. We have then a preliminary arraignment. And preliminary arraignment is where the district attorney is not necessarily asking for detention, but we are saying, hey, these charges, we may need to figure out what conditions of release we could put in place to ensure, one, that you'll return to court, and two, that there is public safety, meaning you won't continue to be rearrested while you're out on bail. And here's where we use a variety of options. We look at bail navigators, and we have that in our office now. And our bail navigators help people find the supports that they need when they are released. Things like getting people IDs, getting them hooked up with insurances, connecting them with people through Hannah's network, connecting them with a community program that already exists that are not really told to them, or they're not given a pamphlet of, hey, here's where you get all these nice services. And so we wanted to use that and tap into the wide range of resources that we have. So we put that into this preliminary arraignment decision-making process. And I believe that this is somewhat what we're supposed to be doing now anyway. This is what the ACLU is saying. You're supposed to look for least restrictive options. And because our courts have never really had an understanding of what's going on outside of our four walls, those options haven't made its way into the decision or discussion. So that would be those who fall into a category of release the ball, but maybe you need some help or support. Then there's that third category. Oops. This is where currently we do not have this. Anyone who is going to be detained on high bail, there is no moving party. It is just a sua sponte, hey, I'm going to give you this bail. And it's almost as if there's a blameless, aspect to this, right? If you can't get out, it's not my fault. I gave you bail, and it's not my fault you couldn't afford it. And so there's no one to kind of own this responsibility. So we believe that there has to be and should be a moving party. If you're saying that a person cannot be released because they are either a danger to the community or a flight risk, then we should have a hearing on that, but you should actually state that somewhere, that this is why you believe this person cannot be released to the community. And then we would have what we would call a release determination hearing. And that would be in front of a judge. And it would be function similar to the federal system. There'd be about 3 days for us to gather information and facts on both sides, the district attorney as well as the defense counsel, and present information at a hearing that would allow an exploration of these factors. And here, because we still have bail on our statute, here is where a person could be subjected to higher bail, or they could be subjected to what's the word I'm looking for?
Preventative detention.
That's exactly what it is.
Yeah.
It's hard to roll off my tongue. Preventative detention, that means they are held without bail. Those things should be rare. We do have that in our statute now, that people charged with homicide could be subject to preventative detention. So these are things that we already currently use. It's not a novel idea. There are states around the country that are doing this. In fact, after we presented our new structure, New York, I think within 2 days came out with the very same thing. I swear we didn't know, but it felt really good to be validated by New York and that they are thinking the same way. So I'm gonna just wrap up with that. This is something that we call our pre-entry model, and it's really putting services on the front end for those who need it. We don't wanna over-service people who don't need it, but we really do think if we start working on challenges in the beginning, there are much better options for outcomes throughout the process. And what we found is that the DA's office has been very receptive to people who have jump-started their own treatment process, and sometimes they are able to be diverted or the case is withdrawn outright. That is the goal. Let's make better decisions on the front end so that everyone doesn't have to end up with a conviction and on probation just because, hey, you're in this system and now we've got to work with you after we've let you sit for months being more desperate, and now you need services that only can be given to you on probation. We disagree with that, and we've seen some amazing results with this model. So I'm looking forward to hearing from James, because I just met him and he sounds very, very smart and intelligent. So I think that's it for me.
Yeah, well, yeah, I mean, I would be very interested in your reaction, James. And partly, leading a center which focuses on the systems approach, I guess what's striking to me about what you shared, Keir, is, I think when we think about the practicalities of how to change these systems, one quickly realizes that, the idea that it's going to be a particular law change or a particular practice, or that, it's going to be one piece, right? So you talked about, well, the police need to do some things differently, the judges, the DA, us as defenders, all the pieces. And also, this involves perhaps a combination of some rule changes, internal policies and norms. And of course, Arnold Ventures, right, has, I think, been at the forefront, particularly as you've been thinking about these issues nationally, about thinking about those different pieces. So I'm interested in your reaction to both the specifics of what Keir shared, but also given what you've been doing now in the pretrial space, what are we learning about this process of reform, James?
Sure. So first, thank you for having me. It's wonderful to be on this panel with Hannah, with Keir, and thanks, Paul, for the invitation. I'll start by saying that for those who don't know, Arnold Ventures used to be called the Laura and John Arnold Foundation. We changed our name very recently. And one of our big areas of philanthropic investment is in criminal justice, which is where I spend all of my time and have spent my career. And our pretrial portfolio developed some 8 or 9 years ago at the inception of the foundation, thinking about what is the biggest challenge in criminal justice and how can we take a swing at it. And one of the big challenges at that time was thinking about pretrial. So Arnold Ventures, we spend all of our time on evidence-based policy and thinking about interventions that we think we can test and scale and research that will actually have a bottom line impact on real people's lives. And so at that time, one of the things that we funded was the public safety assessment, which is an algorithmic risk assessment used to help judges make better decisions about who should be in and who should be out when they're presented with a particular case at arraignment. Now, in the past several years, this has become a flashpoint in the discussion around pretrial justice and what that looks like, and the role of risk assessment, how important it is, what's a good risk assessment, what's a bad risk assessment, and those are really important conversations, and I really enjoy having those conversations. But the more important conversation to have is to situate any discussion about risk assessment as one type of intervention alongside all the other types of interventions that are going to be really important in getting to a state of pretrial justice. And so I really appreciate the framing you had, Hannah, in thinking about centering community voice and having the input of the local community in how justice is discharged, and Keir, your framework about how we think about policy change in the pretrial space. Those are incredibly important and really sit at the nexus of what we want to do at Arnold Ventures across all of our criminal justice work. And that's part of why we've had an evolution in our portfolio over the past 8 years and what we've learned, what we've seen, and how we advocate for better pretrial justice processes and practices. So a couple of things are worth noting. Number one, we have an end goal, and that end goal is really a value statement. We want to reduce unnecessary and unjust pretrial detention. There are too many people who are behind bars pretrial who don't need to be there. It's damaging to them, it's damaging to their lives, to their families, to the fabric of the community in which they live, and we can do something about it. The question really, and this is what you're getting to, Keir, is how. And that's our bread and butter and what we spend all of our time thinking about. How do we make those aspirational ideals real? And as a policy wonk who spent a long time in the federal government, I just love this stuff, and I think it's so very important that we actually get to have these kinds of dialogues, because we all agree so much on the end goal, but the steps and process to move government forward are really complex. They're entrenched. They involve statute, regulation, court process, rules, finances and resources, and then of course politics. And so when we think about pretrial justice, all of those things are true. What we say at Arnold Ventures, and part of the way in which we've articulated this, in the past couple of months, we released a statement of principles on pretrial justice to clarify exactly what we mean when we say pretrial justice and what we think is most important. And one of the key principles is that we want a significant reduction in the use of cash bail. That cash bail is simply a fundamentally unfair practice the way it is currently instituted. Nobody should be held in jail for any reason simply because they cannot afford bail. That absolutely abrogates any sort of rational nexus to why we would or should give government the authority to hold somebody behind bars. And so we need to reform that. As we step forward into a place where it seems like a lot of states and a lot of jurisdictions are considering what does the world look like if we either reduce the use of or eliminate cash bail, then the question is, what structure do we put in place in order to allow for us to, number one, preserve the presumption of innocence and maximize liberty, and number two, where necessary, protect public safety. Those two things are the fundamental questions of our law enforcement obligations as a society, and every single jurisdiction has to ask and answer those questions. So for us, and this is included in our statement of principles, it's important to note that most people are really low risk.
Yeah.
Most people who come before the court at arraignment are really low risk. And so if they're low risk, and if the charge on which they're being hauled up is unlikely to even result in jail time, even if they got through the process, then why do we hold them pretrial? If probation is the likely outcome for a particular charge, if they're convicted, why would we hold them in jail pretrial? That doesn't make sense. And that leads us to another key principle that we would like to see, and that a lot of jurisdictions are now talking about. What category of offenses can a jurisdiction identify that would allow arrested individuals just to be released? Because we know we actually wouldn't want them held. Expand that category, as we say in the industry, reduce the detention eligibility net. If we reduce that, then we automatically shunt a whole bunch of people out of the system and prevent them from criminal justice contact in the first place. That is a really important piece of the pie and something that goes under-discussed when we're talking about pretrial. Once you get into the pretrial phase, then the part that gets a lot of controversy is around how do judges then make their decisions. And what we've heard from judges across the country is that they have an obligation. They have an obligation under statute or state constitution to consider risk. That's enshrined into the vast majority of legal precepts in every jurisdiction that we have. And they do that, and they do it to the best of their ability. But when you're faced with the volume of cases that an average judge sees at arraignment, they're making these decisions very quickly. And what we really want is to be able to give them as much information as possible. And that's where a good evidence-based and validated risk assessment can be helpful. That can help bring some measure of consistency to an inconsistent process and support judges in making better decisions. But one of the most important pieces is that we don't think that any risk assessment, even the risk assessment that we supported the funding of, should be used to make a detention decision. We think it should be used to identify who can be released, what conditions might be helpful to those individuals to bring them back to court. So this actually gets to the needs point that you were talking about, Hannah, which is incredibly important. Court reminders are huge, incredibly impactful in making sure that people get back to court, and that helps us distinguish between the concept of willful flight and folks who may have other obligations or not be able to get back to court. The more we are able to provide those kinds of supports, then the less we're going to see people fail to show up for their court dates, and the less we have FTA. And so in my conversations with folks across the country about how they can move forward into a new and fairer system that doesn't penalize people who don't have any money for the fact of their arrest and the kind of charge that they face, not a conviction, just the fact of their arrest and the kind of charge that they face, we like to identify, number one, that jurisdictions should be shrinking their net. Number two, judges should be making the most informed decision possible about who is in and who is out, based not on wealth, but on whether or not somebody will show up or if they're a danger to society. We think risk assessment can help that, but it's ultimately always a judge's decision no matter what. Their discretion is always going to be preserved and always should be preserved. That's why we have judges, to be able to make these individualized determinations. We think that those determinations, if they're informed by a risk assessment, should be about finding the right conditions that will help somebody come back to court and identifying those people who can be safely released. And then to get to your framework here, we completely agree with the idea that any preventive detention that a judge imposes should be on motion by the prosecuting attorney. There should be a robust procedural process that protects the constitutional rights of the defendant before they go to jail. That's incredibly important. And so with those things, if we reduce the number of people who are coming into the system in the first place, if we allow judges and help them make better decisions, and if we are rigorous about protecting the constitutional rights of defendants or arrested individuals when they come into the system, then we start getting to a place where jurisdiction by jurisdiction, we're moving to fewer people behind bars and a fairer and constitutionally sound process that preserves the presumption of innocence that is bedrock in our system, but also protects public safety, which is incredibly important. So that's the framework that we put around our pretrial justice work. And Paul, to get to your question about what's next and what we see on the horizon, there's so much work to be done here to move from where we are, where the vast majority of states use cash bail, to an alternative system. Now, we're focused on looking at all the jurisdictions who are potentially moving. A lot of that is legislative, whether we're talking about SB 10 in California, SB 439 in Ohio, thinking about Iowa and their pilot projects, New Jersey and its Criminal Justice Reform Act, New York and the Reform Act that they just passed. There are any number of jurisdictions now who are wrestling with exactly these questions, and they're all going to do it slightly differently. Where we think we can be helpful as a philanthropy is to support the research and innovation that can help spur those changes. And that looks different place to place. So we support risk assessment, sure. We support public defense work. We support better prosecution work. We support research in those areas. We support advocacy in those areas, communications in those areas. The idea being that we need to push on all these levers at the same time if we're going to get to our end goal, and we can't afford to sit back and try out just one if we know, and I think that everybody in this room would acknowledge, that we have a criminal justice crisis in this country and reform is needed yesterday. So it's for that reason that we recently launched our National Partnership for Pretrial Justice, which is an umbrella architecture for all of our grantees who are doing this work. There's so many different organizations who are taking different approaches to CJ reform, to pretrial justice reform, and we want to make sure that we use whatever leverage we have to support and galvanize them, to bring them together and say, even if you don't agree on everything, and we have folks who have wildly divergent opinions on the ways that we can get to that end state of justice we're all looking for, we all still share that end goal. And the most important part is that we support all of these different types of entities in the ways that they are trying to move forward, so that hopefully in the next couple of years, while we have this focus, this opportunity, and this national consensus around the need for reform, we can be supportive and take that opportunity and push it over the edge. So it's great to be able to have this conversation and to have this framing. And I really appreciate the fact that we are digging into the nuances of what it means to practically apply reform principles to entrenched systems, because that to me is how we get to that brighter future that we want and are able to live out the values that we espouse.
Paul, is it okay if I just take a minute just to respond?
Yeah,
to
I was
things?
gonna, yeah,
Oh,
please.
great. Cool. And I think we have a pretty good flow
Yeah.
here. So I think that was really helpful, James. And I think that it might be helpful now to just go deep into those nuances for a minute. Just about, like here, when we were doing our prep call about this, you asked me to share a little bit of broader light on the practical analysis of like how factors work in risk assessment to make a score. And so one of the things that I think we haven't talked enough about in this conversation is power, is about like who really holds the power to do things to fight for a community definition of what safety means, or to do things to fight for, to actually set the cut points about what risk really means and what risks communities care about. And so I want to talk a little bit about a process that a number of us went through here in Pennsylvania when our state sentencing commission tried to put out a risk assessment, not for pretrial, but meant for sentencing. So the risk assessment was meant to decide who, or to predict who, after they were being sentenced, would recidivate, meaning get arrested again, within 3 years. And so the State Sentencing Commission was mandated to do this by then Governor Ed Rendell after the legislature passed a law saying that every judge had to have a risk assessment on their desk back in 2010. And they went through many different iterations of a risk assessment in a public body called the State Sentencing Commission. And I think that's very important because we actually had a public appointed institution that included elected officials and defenders and district attorneys and judges that we could engage with, that actually we could file comments with, that we could testify in front of. And they had to publish transparency reports and reports on disparate impact around race as they were developing their tool. So one of the last, or I think it was the second to last version of the tool had a number of different things that caused some alarm in our communities as organizers, and frankly in communities of people who have lived through grievous harm and who have experienced mass incarceration, who by, I think here at Quattrone, we all know, those are the same communities, right? And so that risk assessment tool, and you can go to Penn State's, the State Sentencing Commission for Pennsylvania to read all of these reports, it used arrests 3 times as a proxy for dangerousness. So what that means is that if you live in Brewery Town or somewhere else in North Philly or in Southwest, and you're black or brown or poor, you're going to get arrested again. And so the tool is trying to predict, based on how many times you've been arrested, merely arrested, if you'd get arrested again. Pretty tautological, I would say. When you went deep into its accuracy, the tool was mandated by then State Senator Greenleaf, who, as many people might remember, if you study Pennsylvania criminal justice reform, he was a Republican who was relatively, like very thoughtful and very interested in shrinking the size of the net, as you were bringing up, James, and who moved a number of different bills. He retired a few months ago. But that was mandated to try to look for violence, to really try to predict violence. But the way that the tool was meant to be used was to deny what's called a post-sentence investigation report to at least half of the people it judged, meaning that basically you would get sentenced and there would be no digging into your actual ties to the community or anything about yourself. So to deny an individualized sentence rather than to provide it, the accuracy of the tool at predicting violence was really, really low, right? It was like 18%. And then when we made a big stink about it, and folks who had served some decades in prison, Mothers in Charge, which is this extraordinary organization of mothers of murdered children and other very high-level, acts of harm, when they all went and said, hey, we really need individualized sentencing. Here's who I am as a person. Here's my story. They redid the tool, and they put convictions in there, but it only improved the racial disparities of the tool by something like 5 or 6%. It wasn't very much more accurate at predicting those things, and so as of right now, they've shelved it, they've scrapped it, and they're trying to look at other ways to do what we all want to do, which is to reduce in Pennsylvania, we have massive problems with decades-long probation and parole tales. That's something that Keir focuses on a lot. And we have the highest, if you take a look at Prison Policy Initiative's analysis of either people who are sitting in cages in state prisons or people on probation or parole under state supervision, we are right under Georgia. We're the second highest level of that kind of either open air or in-prison incarceration in the country. And the tool that they built was trained on all of that. So just to close out, I think that we need to really think very deeply about taking the principles that you're laying out, James, and also, the Defender Association, as well as over 100 or other groups signed on to a statement of concern about risk assessment in pretrial and a set of principles about how to reduce its harm that was authored by the Leadership Conference on Civil and Human Rights, a major mainline civil rights organization, also signed by the NAACP, the ACLU, really talking actively about these challenges. Without community voice, without real people who have deep analysis of how the system has impacted them, either as a survivor of harm or as a survivor of mass incarceration, these really small nuances, like where you set the cut points, like one last example I'll give about the State Sentencing Commission, which boggles me, is that when you take a look at the racial disparity report, the racial analysis, they basically decided that it was fair, that their tool was just as fair at judging black people and white people, because they decided that black people were 11% more criminal as a base rate than white people. Right. So for me, I just categorically deny that. I just refuse to accept that. I actually think that black people are more criminalized and their behavior is more criminalized than white people. I think we have a massive record in the Commonwealth of arrests and convictions of things like marijuana possession or possession with intent to distribute that simply don't happen in the white community, for example, and that we're criminalizing other behaviors as well. And so, until we actually have human power to look at the roots of data that can be easily rebaked as objective, and I'm not saying that, I think that Arnold is actually paying a lot of attention to this, but just to close, I remember sitting with you, Keir, and the chief defenders of the country, sitting around a table talking about this, and I remember one of the chief defenders, I think it was of a city in the South, saying, my people come back to me and they say that they locked up my client. The judge held the risk assessment over his head and said, counsel, I can't let your client go because the tool says he's scary.
That's right.
And so despite the fact that you have these amazing intentions and plans, and I think that we can get there, and we want to work with you to get there, when we actually go down to the place where criminal justice is adjudicated, it ain't happening. It's not. And so we have to really contend with power in this conversation.
So I appreciate that, Hannah. And what I would say, it's so funny, I remember when the Sentencing Commission convened a meeting in Harrisburg to talk about this rollout of a new risk assessment tool at sentencing, and all of the counties that were going to be pilots were in there. And Philadelphia, I think it was myself and Mark Holden, who was our then policy director, we were raising our hands in disbelief while everyone else was nodding their head and oh, okay, this sounds great. I think we were the troublemakers in the room, and that sparked us reaching out to the community groups and Hannah, and then, wow, we still haven't had that risk assessment at sentencing, which is great. But I do want to say something on the practical analysis. I'm not, I'm not scholarly in terms of the policy, but being a practitioner for many years, representing hundreds of thousands of people, and then being an administrator where I do look at policy, I see so many flaws in what a tool cannot pick up that a human could understand. So let's just take, for instance, how this system works, right? If you are charged with a felony, you have to come to court at a minimum 8 times. Yeah. Minimum. That's if everything goes well. If it doesn't, and meaning if discovery is not ready or if someone doesn't show up, that stretches out longer. So if you miss, say you had to come to court 14 times, you miss 1 out of 14 times, that goes down as what's called an FTA. A tool picks that up and says, wow, you failed to appear. This may be an indicator of flight. When we're saying, wait a minute, no, he missed a court date, but he cleared that up 5 days later. Tools can't pick those nuances up. And so when you rely on a tool to make those determinations of processes that they can't understand, or don't have that human understanding that, hey, we know that this person works and they've showed up and the complaining witness hadn't shown up 3 times and they showed up every time, does that make them a flight risk? Or does that make them just beat down by the system. Those are two different analyses. Secondly, I am very concerned of the racial disparities that this tool will generate. And some of what Hannah said, but I know, for instance, when I was working in two different systems in Philadelphia and Montgomery County, and in Montgomery County I was the chief defender, but we still had to take on some cases. I saw an enormous amount of diversions being given to clients who are white that I would never see be given to black clients in Philadelphia. And so when we're talking about diversions that allow for expungements at the end, when now these people who are coming before them on the tool may have had these same arrests and, I guess, non-convictions that ended up in expungements, that tool is not going to pick up their risk factor, but instead would pick up a person who didn't get the benefit of that diversion and expungement process and count them as more risky than others, even though they probably have the same offense status based on the natural arrest. So we're looking at factors, and one of the things that I've seen some tools produce were factors such as age at first arrest. You know, this bothers me because I know, and I know through statistics, black children are 47% more likely to be arrested than white children. So if we are talking about a tool that looks at age at first arrest, there's going to be a huge disparity there. And we're fighting every day to make sure that all children's behavior is treated the same. But we know realistically and practically that's not happening. So when I'm talking about putting the humanity back in the system, it's the natural understanding, the natural explanation of behavior that a tool just cannot do. And while we're saying that it's a guide, what happens is it becomes the clutch. It becomes the deciding point. I don't know how many judges will look at a tool and say, this person's a high risk, and say, I'm going to reject that. Because that's just naturally not how people operate. And this system that I just showed does not have a risk assessment tool attached to it. Instead, it has a human assessment. All the factors that one would want to understand could be understood by a human, just analysis. Has this person frequently failed to appear and why? Has this person absconded for a long period of time? Has this person had a history of violent convictions that they've had a long, lengthy prison sentences imposed on them? What can't a person pick up that a tool would be better at?
If you want to
respond, I got a couple of thoughts in response.
Yeah.
So I agree with 98% of what you just said, Keir. I think it's incredibly important to have that human decision-making. The judge is the arbiter of who goes free and who does not, and the judge should be that arbiter. And that's part of why our principles of limitation are that any recommendation by a risk assessment, which is simply an input for a judge, cannot be the final determinant of whether or not somebody goes to jail. And more to the point, any input from a risk assessment in our estimation should be about release. Anything that goes to detention has to go through a constitutional process, and that's the most important part, that there has to be that procedural process, which is what you have outlined in your system, so that makes complete sense. The second piece that you're talking about, the number of times people have to come to court when they're charged, that's incredibly challenging, and part of what we advocate for is speedy trial provisions to make sure that we are thinking about the case processing system, managing that system better, and seeing if there are ways to make it more efficient, because the amount of time it takes for somebody to actually get to arraignment, to get to their hearing, it's unconscionable. Being able to speed that up is critical to having an efficient and fair system in which people aren't then detained unnecessarily. The combination of those two things, the fact that we always want a judge to be in charge of decision making and never want an algorithmic risk assessment to make the decision, we want that to be a way of looking at data more consistently. What you have put before a judge, and even in your system, they're going to be making a decision about who's in and who's out based on whether or not they think somebody will show up or if there'll be a risk to the community. That's the decision every judge will have to make no matter what. So when they're looking at that docket and they're looking at that rap sheet, the question is, are they going to be consistent in making that decision case to case? That's really important. And what we know is that human decision making is pretty flawed. It's been shown by research to be pretty terrible. But human decision, when assisted by validated and evidence-backed risk assessment, can be better. And that's the most important piece of the puzzle, is that at the end of the day, even with a robust and sound system where you have constitutional protections for who is in and who is out, a judge will ultimately have to make that call. And what we have seen is that judges making those calls by themselves with no consistency in how they're looking at data and nothing to rely on can be inconsistent. So everything that you said makes complete sense, and our view of the world when it comes to pretrial justice and how we can create a system that allows more people out and protects the rights of those who are considered, and the point is being considered for pretrial detention, we fully agree with that. The question always comes back to, as a practical matter, how is a judge going to make that decision based on what information that's sitting in front of them? And are they going to do the same thing for every defendant that comes across their docket? If there are ways for us to improve that and allow for more consistency case to case, then we should try to adopt those measures and make sure that we're giving the tools, the judges the tools that they need to be able to make that consistent choice.
I mean, I really appreciate this conversation, and it, I think, connects with one of the questions we've got from the audience, which is, you've done a good job of convincing at least one person that, okay, yeah, this makes sense, right? We're kind of on board. These seem like common sense efforts, but then the question is, what's the problem? Where's the opposition? And I think the discussion, if I were to answer that, but I want to hear you, would be, I think one of the things this discussion surfaces is in some of these domains, the quality of evidence is still kind of scant, right? And so we can have, two people both who support reform, and one stand up and says these tools are going to be problematic, and another, if we had someone here from New Jersey, right, they would say, hey, we've reduced our pretrial population by 25%, and that wouldn't have been attainable as a political matter without the tool. So, who's right? The answer is, we don't necessarily have as much evidence on that and other things. But that's I'd be interested in your thoughts about kind of the obstacles and opposition.
Just really quick. So Philadelphia has reduced its prison population by about
45%.
Yes, without a risk assessment tool.
But, we started from 4 times, kind of the average.
There's no
a pretty
doubt about
terrible
it.
place to start with, right?
But wherever we started, we've done a good job at reducing from 45% without a risk assessment. And one of the things I just want to say is, yes, I think individuals who make decisions without a lot of information can be pretty bad. But when you have an opportunity to present a fair process where information is flushed out to meet those hurdles as to whether or not someone would come to court, what do they need to come to court, if they need anything at all, and whether or not someone will be a danger, and whether they need to keep from being rearrested, that makes a better decision-making process, because you're bringing people in to this system that can force humanity and force unbiased decision-making, because otherwise, these hearings go on without the community, without the people who care about that person, without people saying his or her life matters.
Oh, we agree with
And
that.
so I think that, that's what's missing in a lot of these decisions. If you go along to some of these systems that don't have counsel at first appearance, that don't
Most of them.
That don't even allow, even if you do have counsel, how real is it? Don't even allow for the
conversation.
counsel to talk to them, and don't allow for the person's family or community to be engaged in that process. Yes, the decisions are going to be biased 90% of the time.
So let me just jump in to talk a little bit about data, because that's what you were just asking about, Paul. And you brought up New Jersey as an example. And I think that the thing that's really interesting about New Jersey, there's 2 things that are interesting. One is I talked to Alex Shalom, who, along with the Drug Policy Alliance and a variety of other powerful community organizations, worked hand in hand with the legislature and the court administration in New Jersey to make the possibility of the transformative change that they've had happen. And when I talked to Alex, he's like, yeah, well, we started talking about this in like 2013, 2014. And he looked at the numbers for me, and I'm going to bastardize this. And so if you really want to follow up with me, I'll get the actual numbers out of my email or introduce you to Alex to get them from him or to Roseanne Scotti at the Drug Policy Alliance. But just when they started the conversation about pretrial reform in New Jersey, they dropped something like 18 to 20% of the numbers that they had in pretrial incarceration detention, like they just stopped sending people on a variety of different charges to jail just because they were talking about it. Right. And so then another thing that I think is really important about New Jersey, the second thing is that there was massive culture change, transformative culture change. The court administration worked for well over a year talking to all of the different divisions, talking to the legislature, talking to advocates to be like, y'all, we're not using bail anymore. We're not going to lock people up. We're going to send them home, right? That's why Jersey worked. Here's some other things there are independent economic analyses of why other jurisdictions didn't. We have those now, and we might disagree on them, but I really support Dr. Megan Stevenson's work. She did the first independent analysis of the PSA as applied in a state jurisdiction. Kentucky has had it for well over 5 years, I think since 2013, after building first a homegrown tool. And what her research shows, the paper is called Assessing Risk Assessment in Action. She's now an economist in the law school at George Mason. It showed that for the first 6 months, in the jurisdictions of Kentucky, there was a big change in bail setting practice. They stopped using bail and a large amount of decarceration. But after the first 6 months, most of the judges returned to their previous incarceration practice, right? She also found, and she considers it to not be too statistically significant, but I think it's worth mentioning, that in rural counties of Kentucky, right, where the judge is white, because of course, and where the accused person is probably white, the judge would listen to the PSA a lot more often. And as James said, the PSA generally tells you to send the person home, or with some level of, pretrial monitoring, and that they would listen and send the person home. But in the urban counties of Kentucky, where the judge is white, and where the accused person is considerably more likely to be a refugee. Kentucky has one of the highest levels of immigrant resettlement for refugees in the country, black or brown. The judge would go through a relatively onerous process to buck the recommendation of the tool considerably more often and to lock them up. We also see that in jurisdictions that tried to do risk assessment, like Spokane, Washington, they had a pretrial incarceration increase of 10% when they put their tool into place. It's called Safer Light. I know that they're changing to the PSA now. We've also seen in Virginia, which has had risk assessment for a considerably long amount of time, and it's gone through a number of revalidation processes in order to deal with the disparate impact of the tool that they had built on black and brown communities, where it was predicting harm or dangerousness considerably more likely and considerably more incorrectly for black people. And Dr. Marie Van Nostrand has adapted and changed that. But there's also been an increase in pretrial incarceration in Virginia, and they're going through a redo of their process now. I just think it's really, really important to pay attention to the details. And that's why in our statement of concern around risk assessment, I don't know if we can bring it up, it's on the Internet Explorer there, that we did with the Leadership Conference on Civil and Human Rights. We go through the process of saying we don't think we need risk assessment for pretrial. Like, we agree with Keir. We think that by cleaning out the net, as you were talking about, and making a wide swath of changes not eligible for detention at all, we can make sure that either that magistrate or the judge have the time, as well as the defender has the time to do that adversarial hearing. But we also go through a variety, and you can get this if you Google Leadership Conference risk assessment, you'll get this. Go to civilrights.org and you'll find it there. We go through a variety of ways of mitigating the harm of risk assessment. And we think it's real harm in different jurisdictions that have to do with actual transparency. Don't just tell me what the factors and weights say, which you guys do, but we need access to that training data to see truly what the practice is of criminal justice upon which it was trained. They're going through a redesign of the risk assessment, which is, by the way, only for flight and not for dangerousness, as the statute of New York permits. So people totally don't test for dangerousness all over the country. But they're going through a redesign of their tool right now that involves a lot of robust engagement with the community, a research advisory council. And so we can actually have things like transparency and access to the training data of a tool. They're fighting for that actually now in New York. They don't have access to the training data. We can have things like an audit for results. We don't actually care what the tool says. I think we get it twisted a lot. Like, really, we don't care about the racist computer. Really, what we care is what the judge does with the racist computer. Really, we care about how many people are they letting go. And so can we actually have audited results on a regular basis? One of the other issues that we have is actually dealing with the problem of the zombie prediction. I'm not sure if folks have read that paper. It was written by Logan Koepke and David Robinson, called Danger Ahead. It's by Upturn, and it deals with the fact that the practice of criminal criminal justice. So that's what I was getting to for New York. The practice of criminal justice, especially at in the age of stop and frisk, upon which the vast majority of these tools are trained, was racist at its root. And so if you're making a new tool for New York that's at the height of Bloomberg's stop and frisk policies, I'm not going to love it. It's going to maybe be bad. And then we also want to make sure that communities who have the impact, to bear the brunt of the impact of pretrial incarceration and of harm, are a part of the recalibration, design, and testing and auditing of a tool like this. Like, believe me, when we started organizing on this, and I've been doing community organizing in poor and working communities, primarily of color, my entire adult life, all over the country, and especially here, you know, we thought maybe people would be like, this is better, but people are like, I lived through sentencing reform, y'all. They were like, I lived through the time when they set mandatory minimums and maximums and tried to standardize sentencing policy, and it led to the largest incarceration of Black and brown people since the end of chattel slavery. You know, and I remember talking to Michelle Alexander about this, and I'm like, maybe she's gonna have a different analysis than me. And she said, Hannah, is this just racial profiling? And I'm like, I don't know, I think so, ma'am. It seems like it. And and she wrote a beautiful piece called The Newest Jim Crow about both the massive expansion of electronic monitoring, both in criminal justice and in immigration, as well as risk assessment last year in the New York Times. And so I think that the place where I'm really excited for us to work together is to take the incredible principles that you folks at Arnold Ventures have put out, James, about like judges can use this as one point of information. You have to really push for release, and about really making that a conversation in as many jurisdictions as we can that valorize the role both of the defender that is fighting for that constitutional liberty, as well as the community that bears the brunt of this. And I don't think we've seen nearly enough experiments in that. That's what we're fighting for here in Philadelphia, is to try to get community organizations and people who've experienced this to actually be at the table in setting these decisions, and we haven't been there yet. So I'll stop, but I just wanted to mark that we do have data, and more of it is coming out every day. And so it's about actually trying to make a case for communities determining and defining what risk really means.
If I can, on a couple of points that I think are really interesting and are important. The Kentucky example is a great one because people have used the Megan Stevenson article is fantastic, but people have seen that article interpreted in different ways. The question of concurrence with the given risk assessment and whether or not a judge follows the recommendation of the assessment a certain percentage of the time or does not follow it becomes a flashpoint for the political persuasion of the particular actor. So some would say if judges follow an assessment, whichever assessment used, they follow that assessment 35% of the time, then that's terrible because it means the assessment's bad and they don't want to use it. Others would say that's good because the other 65% of the time the judge is exercising their discretion. And so the conversation that we have ends up being a really hyper-local conversation about what it means to have an input that informs a decision. And we need to be able to have those conversations in every jurisdiction where people are thinking about pretrial justice reform, which is incredibly important. The broader point, though, is that we are never going to be able to tease out the singular impact of one intervention unless we do a lot of discrete long-term RCTs in given jurisdictions. And those are things that we do, and at Arnold Ventures we have an entire team that does RCTs on different things in not just criminal justice but other areas. But when it comes to criminal justice reform and what we're looking for, we don't have 5 or 7 years to run that RCT in a jurisdiction to tease out that particular impact. So what we do is advocate for holistic reform. For all of the things that you've talked about, Hannah, and that you've talked about, Keir, and that we articulate in our principles, if we're actually going to get to an end state of pretrial justice, capital J justice, then we're going to have legislatures and executives and administrators who are willing to move forward on a number of different interventions all at the same time, because we know together we're seeing results. We see that in New Jersey. We see it in Mecklenburg, North Carolina. We see it in Lucas County. We see it across the country where people are thinking about holistic sets of reforms. They see impact. Now, it's great as an academic and research exercise, which is really important and part of what we do, to try and isolate the individual effects of a type of intervention, but that is secondary to the end goal. And we are incredibly excited about all the momentum state by state that we see in legislatures and in executive mansions for states to take the next step in pushing for comprehensive reform in their jurisdiction. And so we enjoy the conversation about risk assessment. We think that is important, but it cannot exist in isolation. It has to be conjoined with a conception of how we reduce the number of people who are in the net in the first place. It has to be added to a sense of procedural due process and protecting constitutional rights. It has to be added to the sense of public defenders are massively overloaded and overworked, and how do we reduce their caseloads and allow for real procedural process to take place?
Also underpaid.
That too. All those things have to be in the mix for real pretrial justice to come about, and we are going to continue to push on every single one of those all at the same time and not fall into the trap that we get into sometimes of saying, well, because some people see an intervention as a panacea, we should focus solely on that. That's never been our goal. It's not our approach, and we're going to continue to remain holistic in our view.
I just want to say something to the whole public defenders are overworked and definitely underpaid. The whole system is overworked.
That's right.
The whole system is overburdened. Prosecutors are overworked. That's why they can't make the best decisions for what we need them to make decisions about. And that's why you see a lot of plea deals being made for people who that some would consider dangerous because they can't get cases together. Judges are overworked. That's why we have 2 minutes per hearing where we can't get these things out. So if we keep framing the discussion of who's overworked in this system as just public defenders, we miss the larger issue in terms of making decisions quickly with very limited information. So if we look at it as that our whole system is overworked, and how could you make the best decisions if you're rushing through this because it's been a process-oriented system, and what do you think is going to seep in then? Your own judgment and bias because you don't have anything else. Because it's so overburdened, you're just getting through your list. There are judges that have 70 cases on their list. Not all public defender clients. 70 cases. Can you make decisions, good decisions, for 70 people per day? So I really want to broaden that conversation about who's overworked in this system. And so when we're talking about shrinking the net, we're talking about how do you make the right decision and what amount of time should you even allot yourself to be doing that. And so I just wanted to make sure that
Really
came into the conversation, because I think this has been talked about as public defenders, and everybody's saying, well, you're going to get a sham, decision or outcome because you have a public defender. Well, you're going to get that because you're in this overburdened system.
Yeah,
And just one quick thing I want to add to that. It's the overburdening of the system, and honestly, not just in cities, but even in rural communities, especially in rural communities, that makes us have a little bit of pause about a risk assessment. Like if the tool isn't transparent and doesn't tell a judge why it's made the prediction that it's made, of course the judge is going to be like, here's information I have, and they don't have the capacity to challenge it. And so I just wanted to mark that very quickly.
Yeah,
Can I say one thing on that? Because I think
Yeah, we're
that
loud.
is actually really, we're in this like really interesting public policy dialogue. I love this, but that is where the rubber meets the road on the use of a good and evidence-based risk assessment is, do you have input from the key stakeholders? So when we do technical assistance support, and we support organizations that go out to different jurisdictions and they say we want to make a particular change in our pretrial system, whether it's risk assessment or otherwise, one of the most important things is who are you talking to and who gets to make the decision. For the most part, everyone's going to start with their government stakeholders because those are the folks they go to, those are the folks who have the most power. This gets back to your original point about power, Hannah. And the second order question is, okay, well, if those are the folks that you're going to and those are the folks who will administer this system, where's the community voice in that?
Right.
That is the part that gets left out of the conversation, where local policy preference has to get expressed, and local policy preference often just reflects the structures of power. That's fine at a certain level in as much as we have elected officials for a reason, but there also has to be an accountability process for these new procedures that factors in community voice, and that becomes a jurisdiction by jurisdiction, site by site question of how you're engaging your local community, how you're engaging your marginalized communities, your communities of color. Are you actually engaging the folks who are most impacted by the system that you're administering? And to our mind, that is the most important thing when it comes to a risk assessment or any other intervention, that those local stakeholders get to determine what it means. When it comes to an algorithm is spits out a number, but that number doesn't mean anything until a judge says it means something, or somebody in the AOC says it means something. And so that conversation has to be a more inclusive and holistic conversation in the jurisdiction, so that those levels are set according to what the community and local stakeholders want. I just wanted to make that point because I think that goes undersold in our dialogue, and we do have an opportunity here to really shift the way we do our public policy and bring more people into the fold.
So I want to draw a couple of threads from the conversation and connect it. We actually have a couple of members of the audience who submitted the same question, so there's some interest. So you mentioned, Hannah, talking about the cultural change that was necessary in New Jersey. You've talked, James, about the kind of hyper-local conversation that's required. And so these two questioners, and for better or for worse, they focused on our judiciary, but they said, how do you get the cultural change among judges? And a related one, hey, this process of needing to make decisions and weigh evidence is something that judges have been doing for a long time. And, so how do you get them to think differently? I think you've, interestingly enough, cited one potential solution, Keir, right, which is, if all of a sudden you have a lot more time to make a decision than you did previously because we've diverted a lot of cases out of the system completely, maybe you do some different things. But I'd be interested if you have other thoughts about the culture change as it specifically pertains to the judiciary piece.
Sure, I'm just going to talk really briefly about this. So I'm a one-trick pony. I'm a community organizer, and so I really do think about transparency and power. And here's a couple of granular ways that that's happened here in Philadelphia. We have 2 live court watches happening in Philly. To define a court watch, that's, everyday community members. Often it's retired church ladies with like a bingo card of basically what to watch for in the courtroom. Like, what did the judge say in this particular case? Like, what was the decision? Gathering granular and independent data. One of the court watches was run by the ACLU, which was the basis of their writ of mandamus about the different magistrates of the court saying, y'all aren't following the actual rules of criminal procedure of the Commonwealth of Pennsylvania, and we're going to get you now. And like, they literally named all the magistrates and had deep records of how arraignments were going. The other one is run by the Philadelphia Bail Fund, and it's focused on a number of important procedural issues, one of which was the fact that there wasn't a microphone that either worked or that the DAs were talking into during arraignments. So both in meetings and conversations with the DA, as well as with courts and major work with Chief Bradford-Grey, now there's a working microphone, and what that permits is, again, more transparency. So we actually know when the problem is at the magistrate level, making the decision about pretrial incarceration or bail setting, and when it's coming from the DA, for example, which often it does, or in another particular situation. The other thing that I want to mark is, at least in Pennsylvania, we elect our judges. And so a lot of us who are a part of doing the electoral work around the district attorney and doing accountability work there are like, why aren't we doing the same kind of work around judges? It's very, very hard to unelect a judge. I think that's happened maybe once in recent or modern memory here in Philadelphia, but it is not hard to start to set a standard of what we think a good judge should be doing. And we do think a judge should be working to unwind a practice of mass incarceration that is racist at its root. So we're currently, with those live court watches, with a 501c3 table setting standards about what we think a judge should do, called the Judge Accountability Table, as well as C4 groups currently working with candidates for our Court of Common Pleas and with municipal court. We have 6 open seats right now. We'll have over 20 seats open in 2021. We're starting to do that level of transparency. And the final thing I'll say is that in Harris County, which has been a hotbed in Texas of reform that's been deeply centered in community power, at Texas Organizing Project, at their local Faith in Action chapter, Faith in Texas, and amongst other major community institutions, they elected a totally different slate of judges, primarily Black Democratic women, and one socialist with a really cool haircut. And the minute that those folks were elected, their first action within 48 hours was to stop fighting the lawsuit about their bail setting practices in misdemeanor court. So we think that transparency, as well as using the power of the vote, is one important set of steps.
I would also say, just by working in this structure, you have to understand that judges are the most insulated
Yes.
to what's going on outside. They really are. And I think it's based on, I don't really know what it's based on, honestly. I do understand that there's certain conversations they cannot be a part of. I know, my husband's a judge, and there's certain things that he can and cannot do. But I think that hurts their ability to see what society needs. They're making decisions on what's best for communities, and they don't even understand how that community is changing. And so when you're working with leadership, because you have to work with the leadership to change these structures, these are the people that have been in these systems for a very long time, meaning in their position as a judge for a very long time. They've probably had the least conversations or been involved in the least amount of panel discussions about these new societal changes or advancements that go towards civil rights. And I really do see, like, and I don't want to call it this, but an uninformed understanding of what we're doing. And I think that they should be required to have more education on community needs. They just started to have continuing judicial education, so it's CJEs, where they're now, only a year ago, are they required to get constant education, like lawyers have CLEs. Judges just started having to get continuous education on their area of practice. So I think it should be like an ethics or social portion to these CJEs that allow them to see what's going on in the communities that they are making decisions that could be outdated. So I think that that's a very simple, practical area, especially along with whatever Hannah said on the watching and transparency.
I completely agree. Elections have consequences, and when it comes to judges, that lever of power has been underutilized. I think it is becoming exposed. I think Harris County is a spectacular example of the possibilities when you have huge voter turnout and education about local races. That's really important. I think we'll start to see that in jurisdictions across the country as we go forward in this criminal justice movement. The other thing that I will add is that data matters. And the more we have, the better. We invest in that as a significant part of our work at Arnold Ventures in trying to generate that evidence. And a lot of what we hear when we talk to chief judges, administrators, legislators is, show me the numbers. And we all know in legislation and in the political world, numbers can count or they can count for nothing. And we always want to err on the side of having those numbers behind us, even as we make the case for things that we think are unimpeachable from the standpoint of constitutionality. So we will continue to support that kind of evidence gathering and data generation where we see good numbers. Folks are paying attention. Folks are paying attention to New Jersey and their 20% drop in their detention rate pretrial over the past couple of years. We saw Mecklenburg, North Carolina just come out and said they had a 21% decrease in their bail setting after they implemented a risk assessment alongside a bunch of other reforms. So the more we see holistic reforms take place and the more we are intentional about evaluating those reforms and the impact that they are having, then the more likely we are to be able to make the case that reform should happen in places that are considering it.
Thanks. So I want to switch gears a little bit because this is just a fascinating question and I want to hear your responses. So this questioner says, as we engage in this reform process, it's likely, as has existed in the past, for there to continue to be situations involving individuals with outstanding bench warrants, with detainers, other issues that come up. And so, how do you think that solutions in that space fit into this larger reform effort? What should we be doing about individuals who come back and face those challenges as they're going through that process?
I'm sorry.
And so, particularly if you've got, so people with outstanding bench warrants, with detainers, with other things that historically have triggered judgments of greater necessity of detention, right, or greater risk of failure to appear. How do we address those in the context of kind of a reformed system?
Well, we actually have been addressing those, and believe it or not, when we were looking at detainers, we were looking at whether or not, what's the decision-making point to lock someone up if they're on probation and they encounter an arrest for a minor misdemeanor, where they've been doing well, otherwise on probation. Say if they've been working, going to see their officer, there was no hearing. It was an automatic detainer. And so in November of 2017, we wrote the courts, and meaning my office, wrote the courts a letter and saying, hey, we need some due process in this front-end structure, in this decision. A person should be present to talk about some things that relate to why they were, not necessarily the case, but what's been going on with them, that we need to detain them. And that change, we really fought for it hard. And then when Larry came on board, he was in agreement of it. That change alone helped release about 33% of the people that would have otherwise had automatic detainers. Just that little tweak. And sometimes it's just as simple as saying, hey, what's going on here? How is this happening? And what can we do differently? And it was, hey, how about have the person there and have the lawyer be able to talk to them before the hearing? And what we would find is there are often a lot of miscommunications and mistakes about information. Someone could have a bench warrant where they've been with their probation officer for a year and no one's ever brought it up, but it's still stuck in this system. And if you only told me, I'll tell you how to get it cleared up. You know, these misconceptions about what bench warrants mean are really, really incredible, because people just think that means someone is absconded, but they don't know. We had a person, let me just give you this one example. We had a guy who was on probation, 2 different probations for misdemeanors. And he was assigned 2 different probation officers for those 2 different cases. One was on the 11th floor, one was on the 7th floor. Well, he started going to the probation officer on the 7th floor and believed that this, was part of all of the things that he had to do. Well, while he was reporting to the 7th floor, never went to the 11th floor, that person put a warrant out on him, wanted cards. And he's like, well, wait a minute. If only they had told me to go to the 11th floor, I would have done that. But now it goes down that I've absconded from probation. I have a warrant, even though I walk into this building weekly. It's some of the stuff has no common sense attached to it. And the ramifications are so dire for people that we don't start to say, well, do we know if this person is reported on this one? Well, then why don't we just do something about this instead of putting it down as an absconsion and then making it go through this entire judicial process? I think sometimes what we do here, the flaws in our system, debunk common sense. And if people knew that more often, but they can't because it's not as transparent as it should be, then they would say, well, we're not even dealing with dangerous people. We're dealing with administrative processes and procedures that create this narrative that most people are going to flee, which is not true.
So I just want to jump in quickly, and then I'm really excited to hear from James on this, because I know you guys are doing a new project focusing particularly on probation and parole, and I think that this is a really exciting place for Arnold to be working. But just here in Philadelphia, like well over half of the people who are up there on State Road are actually there on either a technical or a new arrest violation of a condition of probation and parole. So I think that that's really important to keep in mind, and that's because, as I said earlier, we have some of the longest tails for probation and parole in the United States. We also, and I promise I contain multitudes, I promise I don't only talk about risk assessment, I really have other interests in my life, I do. But like risk assessment also plays deeply into this in Philadelphia. We have something like 38 to 40,000 people just on a local city sentence of supervision for probation and parole, and they're run through a risk assessment that isn't like the Arnold tool. It's a black box tool, meaning you can't really tell what's in it, and it's also a machine learning tool, meaning it takes a different set of decision steps, it weights and centers different factors for every single person that it judges, and it weights dozens of them, hundreds of them really, because of the particular kind of tool it is, so it's not explainable to a judge or a probation officer, right? And that tool, when you look at its documentation, it was built by a criminologist here at Penn named Dr. Richard Burke. The highest ranked factor in the tool is age, so we talked about age. And the second highest ranked factor in the tool, at least when it was designed, I don't know what's in it, we've tried some right to know requests, we don't really know. The second highest ranked tool based on the National Institute of Justice documentation is zip code. Philadelphia is the 4th most segregated city in the United States of America. And also in terms of procedure, and I think we talked a bunch about this, we don't drop the risk level for people. And again, they're serving 10 years on probation, 20 years on probation if they have a high level thing. And so that means that they're always called high risk, even if they've met every condition. They went to the 7th floor, they went to the 11th floor, they peed in a cup. They did it, Even if they do that, they're always called high, and so they have to contend with onerous and ugly levels of life that none of us would freaking succeed at, just to be real. And so I just want to mark that the devil, again, is in the details. And so when you talk about the intersection of pretrial adjudication with probation and parole, that is intimately necessary to analyze at both the systems level and the lived experience level of people serving those sentences, so they can talk about their brilliance and their success and the contributions they make to the community, and not just how they were called scary 10 years ago, once upon a time.
James, you want the last word for us?
Sure, I will make a high-level point, and I will not dig deeply into our probation and parole portfolio, although it is robust. My colleagues Amy Solomon and Julie James are the experts there, and they're spending a lot of time thinking about how we can incentivize better practices and more just practices when it comes to probation and parole, which will obviously intersect with our pretrial work, and we're really excited about where that's going to go, so more to come on that. But the high-level point, and this gets to what both Keir and Hannah was saying, is that in order for us to get to any sort of system of justice, even if we put into place a whole new set of interventions and revamped how we do business, there's a whole lot of leftover cases and individuals who are impacted by the way in which their cases were adjudicated, and being clear about how we are going to manage those cases and manage that outstanding docket of bench warrants, whatever it may be in a given jurisdiction, requires the input of your defender, requires the input of your prosecuting attorney, requires the input of your AOC, requires the input of your community. And this is I think the theme that you're hearing me hit upon today over and over again, is that in order to get to an end state of pretrial justice, to reduce the number of people behind bars and continue to have an evolution towards a more just system day by day, we're going to have to continue to have these policy implementation conversations that are not just about, reducing a number. It's about the how we do that and how we continue to engage key stakeholders to keep pushing forward, so that inertia doesn't take us back to the place where we were or the place where we are right now. So I really think that's an important question, and one that every single jurisdiction who's thinking about reform is going to have to wrestle with in an iterative and ongoing policy process.
Well, I want to thank the three of you, because I think you've exemplified the sort of policy conversation that we want to engage in, that it needs to continue here in the panel. I wish we had another 90 minutes, but I hope that the audience will take the advantage during the breaks and other things to continue this conversation. If you can join me in thanking the panelists.